you're gonna have to get up for a minute. We need to move her down a little bit.
Down this way?
Yeah.
Yes, I can see that.
I can see and I can hear.
Okay.
He doesn't like me.
No, I'm gonna move down towards you.
Yeah, we need to make space. Okay, so no worries, we're just getting it ready for the next time, right?
Yes.
Okay, you're happy to move.
Okay, guys, good morning. Can we start?
You two back there here, Bertha?
Yeah, what's going
on?
I
Okay,
can even see
that's
her.
good.
I don't know if Desiree can, but I can see her. Okay, very good, very good. So basically, what we are going to do is to continue today, we are going to continue talking about the contracts, about the offer. Buyer's offer today, that's the topic. And before doing just this, I would like to bring your attention to real estate bulletin, which I printed to bring to your attention several points here. Margaret is doing everything possible to comply with the DRE rules and regulations. And how do I know that? It says right here, a licensed real estate broker must supervise the real estate licensees who are affiliated with the broker. Nothing new here, right? A broker's failure to provide adequate supervision can lead to disastrous consequences, not only for the affected consumers, but also for the broker's future in real estate. So, and then this bulletin talks about several things that I would like to bring to your attention, and that's just to ensure that you understand, and I know you do, that Margaret is really doing everything she can as a broker. So the commissioner is looking for transactions requiring a real estate license, documents that may be of material effect upon the rights of or obligations of a party to the transaction, meaning that all the paperwork that we keep talking about, she needs to have. So that's what we're talking about. Then, of course, advertising, she's responsible for that as well. But familiarizing licensees who work for her with the requirements of federal and state law relating to the prohibition against discrimination and other laws, she's doing that. Regular and consistent reports of licensed activities of the licensees who work with her. She needs to do that, and she is doing that as well. So the reason I wanted to make sure that I bring this today, because I saw Margaret's several emails, and she's absolutely right. I support her that she's asking all of us to do everything possible to make sure that we're all good and the license is intact, and she's out of trouble, and we're out of trouble, and our clients are out of trouble, and that's what we're doing by offering these classes. Very good. So what is the first word that, or the second word I should say, that we see on California purchase agreement? No, the second word. What is it? What does it say? California purchase agreement, first page, second word, what does it say?
Residential. This is an offer.
No, not the title.
This is an offer.
This is an offer from, right? The word offer, that's what I'm referring to. So the word offer is the first word basically that we see on this document. So why do we have that? That's interesting. Why do we have a contract and offer kind of in the same document? Does anyone know?
Because it's negotiable.
It's an offer to purchase.
It's an offer to purchase. So it brings me to the question, according to the guide. So we would need to move so that we can see the handout, right? So we need to move all that extra stuff. So the first question I have, and please don't move anything else yet, home buyer's offer. The good question, what is it? How do you explain to the buyer what is, Mr. Buyer, your offer? What is it all? Why do we need it? Can someone tell me very quickly?
Yeah, it's a buyer's offer, legal offer to purchase a specific property for a specific price.
Mhm.
And a offer to close in a certain amount of time.
Okay, very good. So we will for now we will use your statement about the offer, and then again, I will show you what I got from the legal documents, how it sounds in legal language, so to say. So my next question to you before we move on, my next question is, what if the attorney asks you, can you, Mr. Agent or Miss Agent, deliver the offer to the buyer, to the seller, I apologize, to the seller directly? Can you do that? What's your answer will be?
No, it should be to his agent if he
No.
has one.
No, and I noticed that Z says yes, right? You kind of nod, yeah. So we have now two opinions, so to say.
If he doesn't have an agent, then yes, you go directly to the seller, which would be.
But she just said, can
Sell
you?
by.
So yes, you can,
Can you?
but like
you
everything.
allowed?
depends.
Are you allowed legally? Is it okay legal or ethically? One answer was no. The
Well,
other was
legal and
yes.
ethical are different.
That's right, but we're not going to go into details right now. Let's focus on my question first, because the next question is very important. So we have yes, and we have no, or vice versa. The next question I have is, what if I will ask you further, how do you know that, Miss Connie? You just said, no, we cannot do that, if this, if
If
that.
I found it on MLS and that shows me that there is an agent,
Okay.
then my ethical responsibility is to deliver it to the agent.
So the quick answer is, I go to MLS, if the seller is represented there, that's the answer, right?
But if you can't get hold of the agent within a 24-hour period, you are authorized to go straight to the seller.
Wait a minute, she said the buyer, she didn't say the buyer's agent who
Yeah,
looks at
I
it
said the
unless
buyer.
the
Oh,
buyer.
I'm sorry, I misunderstood.
Yeah.
The buyer, can the buyer, okay, now let's go back. Can the buyer deliver his offer to the seller, yes or no?
Yes, it
Yes.
can,
Yes? Okay,
Yes.
so in the
and
next
he
question.
is on Old Calaveras Road.
So, and the next question is, how do you know that? And let's not think about it right now. I just giving you a sense what the attorney may ask you. How do you know that? And the key in this business, it turns out from years of learning from attorneys, I learned that it's once you open your mouth, it may be considered your opinion, but not always. It should be your opinion. You should really know what you can refer
Well, the
to.
contract is between the buyer and the seller.
Right. But again, you just brought up we're not going there. A representation issue, we're not going there.
I read it in the textbook.
Right now, the point I would like to make is, that's all I'm trying to say.
Yeah.
That you need to remember, once you open your mouth and say something, it may be considered an opinion, but sometimes your opinion is not really relevant, because you need to know where what you're saying comes from. You need to support what you're saying. You need to know the documents and like the car forms, car advisories, and that's my point. That's what we're going to do.
So
Very
if the-
diligently, we will
If the
learn.
lawyer asked me that, I would say yes in some instances.
In some instances, so the question right now, your answer is correct, but it's not what I said. The bottom line is that we need to know where this information is coming from. Do we have that information? That's the knowledge, that's the competency that I would like to bring us all to. Now, let's go to the first topic, which is home buyer's offer. What is it? Home buyer's offer, it's the first formal communication between the home seller and the home buyer. Interesting, huh? The first step to reach mutually acceptable agreement. A conditional proposal made by a buyer to buy a home which becomes legally binding if accepted. Interesting, right? So all those things are much more complicated, sounds to me, than what Daryl just said. He was really get to the point straight in his own language, but this is actually is required of us to explain things like that. And of course, to be at this level of communication, we need to memorize that, but we don't. With a new resource center, we'll have everything for you over there. And what you need to do is just to send this to the buyer, things like that.
Okay, you are referring to a written offer, am I correct?
Yeah.
Okay, because there are verbal offers.
They're not acceptable in real estate. They're not.
No, they're not legally binding.
They're not in real estate, no. There are several contracts that say, like listing agreement, it's not acceptable verbally because of listing commissions and things like that. This is not acceptable as verbal. We do not have the idea that this contract or the offer may be verbally accepted and it's legally binding. It's not. So, okay, so as you can see by reading this, it's actually very interesting because it really gives you the entire picture of what the buyer's offer is all about. And I think that this is what you don't need to memorize, but it will be good to send it to your buyer upfront and go and move on. All right, we'll also have legal and ethical requirements, right, for the offer. We know that. So there are a lot of them, but I'm going to really focus on several, which mostly ignored. Fair and honest dealing. This is like, gosh, this is like you will say is given. We need to act fair and honest. Is it really happening in life? No, it's not. We all were witnessed when our offers or our buyer's offers were not presented in the past, or something happened to it, or the agent was really rude, or things like that, all kinds of things happening. So it's not ethical and it's not legal. And now we will learn what is really not ethical and not legal. Okay, the duty to act in good faith is a fundamental aspect of real estate transaction. So it may not say on every page, this is what we need to do, this is how we need to act. It will not say on every page, but it is given by the judge, jury, by attorneys, by the whole world that you guys or I as well as an agent will act ethically and honestly. So it's a fundamental aspect of real estate transactions, ensuring that parties engage in honest, ethical, and fair practices from negotiation to contract performance. So it's going on from the start to the end. You need to remember that to do. And the only way, because everyone who sits at this table, a good person, honest person, but again, the lack of knowledge may prevent you to do things right. And that's what we're going to learn. Each party is doing what they say they are going to do and doing nothing that would injure the other party. That means that every single time that I am a seller or I am a buyer, we need to make sure as agents that they're doing everything according to the contract, and that will not injure or jeopardize the deal because of their actions. So one of the examples I would like to bring today to your attention is when you have a buyer who wants to rent a place, right? Who wants to rent a property, and he likes it, he wants to go ahead with an offer, and he tells you, what if he is your friend? What if he is your relative? And he tells you, you know what, I'm going to rent it, but on the contract, I will not put it, right? I will not put it that I'm going to rent it, so.
Oh,
It's
okay, wait a
gonna
minute.
rent it to a third party.
Yeah,
Oh, okay.
yeah, so
Buy it
that's
as a
what,
rental.
a
But
rental,
there's-
yeah,
but
that I
there's
will make
things
it a
you're gonna
rental,
buy
yes,
that
thank you.
because of-
So,
Yes, there
and
is.
what happens then, what would you say to that person? Nikki, what would you say to that person?
If they said what? I was still trying to figure out the thing, first you said a buyer then rental, I didn't know what you were talking about.
Okay,
Now, do you,
purchasing for single.
he's representing himself as an owner occupied, but actually buying it as a non-owner occupied.
Thank you.
Yes, that's a very well put
And what would I say to whom?
to your client. This is your
You
client
always
that's
said that's
telling you
what they're
this.
doing.
You know
That that's, that's what they're doing, I don't know what I would say,
You don't know what you will say?
no,
You'll find out.
what would I say? No,
Alright.
what would I say?
Okay, so the client, your client is telling you that he's going to lie.
Yeah,
That's the bottom line. Do you
Oh, my
understand?
client is the
Is
seller.
you represent-
My client's the buyer.
Prime to
Okay.
the lender, essentially.
Okay, I
Yeah.
totally confused you, I
Yeah.
apologize.
Yeah, you were talking about rental and a buyer, I was like, wait a minute.
But it gets complicated, doesn't it, Bridget? Because maybe they're going to rent out a room in the house, is that?
Well, I would tell them don't lie, first of
That's
all,
still owner.
I would tell them
So
don't
it's
lie.
really about owner occupied,
I mean-
why is owner occupied?
So this is a very good example, because we know people lie, right? People lie all the time, there's no question about that. And we need to be very, very diligent and very on top of everything. So that's a good example, when somebody's telling you that and you will say no. There is a place in where it says in the contract that you need to be honest, and that's what it is. And another thing you may say in this situation, what about the lender? If we are not going to bring it to the lender's attention, then it's a lender fraud, right? That's another way to put it. And it's $100,000 fine and years in prison. So that's what you need
But
to.
that's not how I would phrase it.
Well, of course, I am me and you are you.
You're using the consequences. I would use the what ifs. How the lender's gonna find this. I'm gonna say, you can buy this as a rental, but we need to put in non-owner occupied because you're gonna have a different interest rate. And it's gonna be higher. And if you're trying to avoid the higher interest rate, the lender's gonna wonder where your current owner occupied property is. And if this house is too far from where you work, they're not gonna accept it. And they aren't gonna investigate. So you need to be very clear about how
It
it's gonna
impacts
be.
your ability
Yeah,
to purchase.
so basically lender goes out, they send people out to check.
Right,
That's what they do.
and that's what I would tell him.
Well, just an example, I'm not getting into details, but we all are on the same page. That's what it is. So the honest and fair dealings is the key thing in this business. No under the table, no under whatever. Please remember, fraud is a really bad thing, and it's it's really punishable. Okay.
I need to clear something.
Okay,
So you're saying that the buyer, when they make an offer to a seller,
yeah.
they have to go in telling the seller their intended use for the property?
Yes, it's right here in the contract.
Either owner occupied or non-owner
No,
occupied.
No, yeah, that's different. That's because of the lender's
Right.
involved. If you're buying cash and you go in and say, make an offer,
No, cash is not the subject, yes, only if you
no,
put
you're
something.
misunderstanding.
Okay.
So I don't believe, and I don't think there's any place in there that requires you to tell the seller what your intended use is. If you're paying cash, the reason we tell people that because there's a lender involved,
Right,
we have to tell them for sure that this is.
Yeah.
A rental property or a income property.
Yeah,
So here it is, it says occupancy type, primary or a check, secondary or
yeah.
investment.
because there's no risk
So
involved.
we're talking this.
I understand, but
Yeah,
that's for the lender, it's not necessary, the seller doesn't give a damn as long as he gets his money.
Oh, that's not true.
That's not true.
Yeah, no.
It's not-
I'm not-
it's not, anything is possible,
No,
Mark.
no,
You-
no.
I know it.
No,
I
They
just
don't
had a
care.
seller that's upset that it's
Yeah.
a rental.
Yeah.
And
I've never seen him
and
say.
she thought they were gonna stay there because
But if
this
I
lady
know
came in,
that,
the buyer came in. Talking about the whole time, oh, this is gonna be a great place for my chickens, I'm gonna do this and that, and I mean, she just loved the place, no, I wanna keep the stained glass window, I fell in love with it. So
So-
2 weeks later, it closed, it's as on the market for a rental.
okay, so
My seller is not happy.
basically what we are saying here is that whenever a person puts something that what he represents or she represents, it has to be truthful. Of course, if we are talking cash offer, if we're talking we are not doing this right now. We'll talk about it when we talk financial portion of the contract. Right now, the key thing is we need to be truthful. We do not go along with a buyer. We do not go along with your buyer while putting together an offer, preparing an offer just to keep it going. If something is wrong, you stop it. You stop it because it's terrible what may happen, really, guys.
What about if you what about if you're purchasing a property and it's your primary? You're not really gonna live there, you just have a room there, but you're renting out all the other rooms.
You're still primary.
They're still
It's
right.
your primary room is different story.
My
As
question
long
is
as
a
you
little
have one
different.
room there and you can rent out the rest of the
Right.
house.
Right.
You guys are talking about owner occupied and non-owner
Right.
occupied.
Yeah.
But the lenders, if you put in anything about a termite report, they wanna see the report. And then they suddenly turn into an inspector. So we have learned over years and years and years not to put in termite report. We can put in inspections, but they don't ask for just general inspections, or they haven't so far. Yeah, if you leave out inspections at all because it came in the general.
Why are we
packet,
on
This is
that?
a typical, this is lender fraud.
They-
Yeah, still,
No,
Yeah.
no, Connie, no, this is the wrong practice. If there is a report, if there is a term, that's exactly what I'm saying. Do not do anything under the table. You cannot do that, guys. If there is a report, lender must see it. If there are problems,
They're not required, but they can ask for it.
and
They
you
know, they
just
see.
killed your buyer's deal, so you misrepresented your buyer. You did not represent your buyer to the highest.
They
and
don't
best
have to
use.
see all reports, they see the contract, and if there is some report identified,
So what you're saying that you have a report somewhere and you're not showing it to the lender?
Correct.
Unless they ask for it.
and what we're talking about is when you write an offer and you say buyer's going to, the seller's gotta provide this report, this report, this report. Then the lender has the right to ask
Ask
for
for
it,
it.
we don't just automatically send it. However, I had one once, credit unit required certain inspections on a country property.
VA will require it every time, so
Okay.
we'll let they check.
But
So-
but generally, when we write an offer, we don't, buyer can get any reports they want,
Right,
but we don't specify it in the contract that
Yeah,
they're buying a certain
I was
report.
gonna say, I'm gonna support Berta on this, so within the new world, when you use disclosure IO, you're gonna put all those reports on there probably, and if you had a termite report and a termite inspection, maybe you'd probably put them on there anyway, just so that you could.
But you're not submitting
You do
it
that
to
in
the
both
lender.
commercial
Well, the.
and residential, and they call it disclosure documents.
Yes.
They're separate. And you can say, here's the purchase contract, you're authorized to go here and pull any of these reports and read them that you want. But they are not part of the contract typically.
okay, so let's move on. The bottom line is that I personally, it's my personal take, I highly recommend to do everything you can to push trouble from you by giving everything to the lender, giving everything to the seller. Let them know, if this is something, I will double check that with the attorney, I will double check that with the attorney, guys, maybe
Not
you're right.
requirement.
No, it's not a
Only
requirement,
if
but
it's written in
but
the
what-
contract.
what I'm saying is, once it's in the contract that it is going to be there and you have it, you have to show it to
Oh,
them.
yeah, if it's in the
It's in the
contract,
contract.
that,
Yeah.
That's what I'm saying.
No,
But
we're
okay.
saying,
We
no,
typically
we don't put it in
don't
the
do
contract.
that.
that's
Don't
why
put it
we
in the
don't put
contract.
it in the contract.
I see.
Okay,
Yes,
Z
Z.
has a question, Martha.
Yazzie, please.
So back to where you started, your original question was, if you know your buyer is lying and says they're gonna rent it and they're putting on the contract, they're gonna live there. I would tell them I won't put it in there, cause I know it's a lie.
Whatever you need to do it, discuss, tell them the consequences.
Because then I'm liable if
You are
something
liable.
goes wrong.
Yeah, you're liable,
What
you're
if-
absolutely right.
Period.
What if they don't tell you?
then I don't know,
Then,
You have to
yeah,
find
then
out.
you cannot
But
do
if the buyer
anything.
doesn't tell
but then you don't know.
the agent.
Yeah, they do.
The
They
one
do.
that gets me is when they tell me they're putting 20% down,
Mm-hmm.
or they're paying all cash, like Daryl said.
Yeah.
And then at the very end, I find out there's a lender and it's 20% down,
Yeah, the
and they
private.
have not disclosed that to the seller.
Yeah,
That's a big problem.
yeah. So let's move on, guys. So we got the idea that everything should be honest, we got that, we knew that, it's reiterate the same thing. You don't do anything that will jeopardize your license, your broker's license, your clients, your even the third party, you don't do anything. So let's go to RLA, who is doing this? Is it
It's
Raymond.
Raymond on over there.
Raymond?
Raymond, we don't see you. Hello.
Is he gone?
No, he's there. He's running
Okay,
up.
so let's take a look at those highlighted pages, please, what I have here. Let's go to right to the page.
Which page?
Well, that's what it says, he had it.
Yeah, it's got it. It's just
He
that
had
little
all that, yeah.
triple.
RLA, page 4 or paragraph 4. Okay, yeah, let's go to that
we go.
highlighted, please, stuff.
Page 4.
Is it paragraph 4 or page 4?
Page 4, paragraph 8. 8D, there's no 8D. What happened?
Page 4, paragraph 8D, RLA,
That's
is
not
it
8D.
8D.
Well, that's,
No.
no, talks about it, there's no 8D.
Now
What do we
she's in a
got?
purchase agreement.
What was it
It's
about?
an RLA.
What's
You
the
said
topic?
Residential listing agreement, yeah, that's right.
Oh,
Hold on, please, hold on.
I told her, yeah, we're not supposed to get RPA. That was said already.
Okay.
she said RLA, but I
Okay,
think it says
So let's go to D without A, that was my mistake, go to D, page.
Seller
4
good
D.
faith?
D, 4D.
Seller good faith?
Yeah, so buy, seller good faith. So, as you can see here, it says seller good faith, page 4D. Okay, it says here, seller agrees to consider offers presented by broker and to act in good faith to accomplish the sale of the property, among other things, making the property available for showing at reasonable times and subject to paragraph 2C4, referring to broker. All inquiries of any parties interested and seller is responsible for determining at what price to list the home. So
Okay,
we'll talk
I
about
have page 4 here,
D,
that's 16.
page 4,
The D here says balance of purchase price and down
the
payment,
listing agreement.
listing agreement.
So guys, again, let's go over it again, please. So the key here is that the seller is required to act in good faith when considering offers, when cooperating with the buyer and so on and so forth. So you can see that here and that's what we need to explain to the seller. Okay, so that's very important. All right. Yeah, next thing, please. Next page, Raymond. The next one is
RP.
RPA.
Oh, okay.
Okay, let's
Now
take a
we're
look
in
at
the
RPA now.
Wow.
10P. What is it?
RPA, RLA should be right there all the time on the top.
Page
Okay,
14.
so now let's go to RPA,
RPA, page 14.
page 10, page 10, paragraph 14. What does it say?
Time period, removal of contingencies.
What does it say? Did I give you the wrong one? No, I should not. They gave me the wrong one.
It's only time periods on.
Right here,
Okay.
time periods, removal contingencies.
Okay, so we go to seller deal, okay, so hold on please, guys. It's so much here, so many forms, so many women here, so it should be fine. Just 1 second.
What's the topic?
What are you trying to find?
Yeah,
Okay, page 10,
we were on.
Page 10.
10, and we are going to paragraph 14. Yes, on the time periods, you see that just in the middle, it says right there, buyer or seller must be exercised in good faith and in writing. So that's the only reason I am showing this to you, that you at least know now that good faith words, the words good faith are in listing agreement, are in, and you know that right now. And like I said before, it's not going through the entire contract, that one or this one, but it's there, and that's the assumption is that everything is done in good faith.
Yeah, this one is specifically talking about
Removal
the
of
time
contingencies.
period.
It doesn't matter, but the word, the point I'm making that there is, the words are here in the contract. And before today, before this moment in time, you didn't know that. But now you know that the words are there in the contract.
Which brings a
I'm sure we
question,
didn't know. He said that.
because sometimes when I write a contract, I make the contingency short to get my contract accepted. And then when we get to the end of that contingency, we've done all we can to meet that short time frame. But sometimes you just can't meet it. you have a 5-day contingency for appraisal, you get in and you find out the appraisals are 2 weeks out.
Okay, what's your point?
Yeah, what's your
Yeah,
point?
move off.
What's your point?
So, good faith, I probably knew going in, I couldn't get an appraisal in 5 days.
Yeah, there are exceptions, there are things that happen, but
Yeah.
in this case, you
That's
must
kind of-
deal
sorry,
in good
that's
faith.
edge case.
It's also in the Realtor Code of Ethics that you treat all parties in good faith,
Right,
so.
So the key here is that we have extensions, we have all kinds of things. But when you work with someone, please open your eyes, open your ears, make sure they are not lying. If you can detect that, you need to stop that. Of course, you cannot tell right now, am I lying or not? It's hard unless I point out to the certain document. But this is the key. Before right now, before this moment in time, you really did not know. You really did not know that the words exist. And now you know. They are in the contract. That's my point. Okay, next one. Let's go to RPA page 9, paragraph 11. That's why I'm saying that's always good to have RPA and RLA with you and buy broker agreement with you all the time at all. So let's go to RPA,
Mhm.
page 9, paragraph 11. Okay. So what do we see there? We see there, let me see.
paragraph 11 actually.
Non-material facts, sellers shall.
Okay, let's go to paragraph 11.
And you're looking down at
Yeah, there you go.
which section of paragraph.
Yeah.
11.
Just 1 second. Just 1 second. Okay, just 1 second. I need to get there too. Okay.
So paragraph 11 looks like it's on page like,
A lot.
yeah, it's page 7. It starts on page 7. So where do you want on page 11?
Okay, guys, okay, I see what happens here. So I wanted to go to actually page 9, paragraph 11O. That's what I needed to tell you. O, because it's a huge paragraph.
Yeah.
This one. Known material facts, right? Seller shall within the time specified in paragraph 3 disclose known material facts and defects affecting the property, including and so on and so forth. So, and then what I wanted to show you, this is all known.
There's no O, I've got
There is.
M.
Just on, yeah, just above 12.
Yeah, please, Connie.
Okay, so then this
Follow
one's
the
out of
screen,
date.
yeah, please. So let me point out why I highlighted that. This particular paragraph talks about. So seller has to represent a lot of things, disclose a lot of things. And then it says here in the paragraph, including, but not limited to, known insurance claims within the past 5 years. Do you see that, guys? Or provide buyer with permission to contact insurer to get such information. And here we are talking about car form ARC. So the question I have for you, do we do that?
No.
We don't. So that's another point that we didn't know that until this moment. So we need to start doing that. And of course, we haven't gone through the purchase contract training yet. But last time, everyone who was present heard me talking about this. We need to track events that are required in the contract. Tracking events is very critical. Everything that the contract requires, we need to track. That's how Margaret will be protected, and that's how you will be protected. And that's what we are going to work on. We will
Okay.
start tracking everything that contract.
So let me ask a question. Now, this is a form that could be used if they disclose that there was some kind of insurance, but we wouldn't automatically send them this form. Or with every offer, an
Why
ARC.
not? You will.
This
Now,
goes to a clue report, right?
No, this is for known issues, so this form, if you know there's insurance claims, you would use this form to report the claims.
So the thing of the matter is, let me explain to you guys. When we hear me talking about this, it sounds, oh, that may be what exactly happened, like you explained. What if? But what if you're dealing with an absolutely incompetent agent? who has no idea. So what I'm saying, I'm trying to preach this since day one. What I'm saying is, we need to be proactive. We are better than that one agent is. So there are nobody's asking, do you have this, did you have the claims? How many times did you ask your seller? Nobody asking that, right?
Well, they have it,
It's on
no, it's on their SPQ.
Yeah, it's on the SPQ.
Right, so you check that.
Well,
If the-
I read the SPQ to see
Okay, so but if you are on the buyer's side,
Okay,
you
buyer's,
know,
yeah.
and let's say that this is blank, the SPQ, and that is blank, right? It's your duty to ask because it's in the contract. That's all I'm saying, that I'm not talking about specific instances because it's tons of them. What I'm saying, and I'm trying to ask you, please do not just push SPQ, TDS to the next person in line. Do not look at your documents, what the seller is there, if something the attorney is saying. If that is not marked one way or the other, it should be marked one way or the other. If not, it should be explanation. I don't know. We don't have it. But your role is not just to push this paper to the next TC or next agent. You need to check those two. This is the absolutely a must that you check TDS and SPQ before you send to someone else. And one of the questions is right here. That's why I brought this to your attention, because this is missed. Nobody's
new.
talking about
It's brand new, because here I have a contract from 12/22.
it. It doesn't matter.
Your contract
It
is
doesn't
dated
matter.
7/24.
Nobody cares whether it's new or not. What they
Cannot
care is
lie.
about, you have it in your hand, it's now yours. You're liable for this. You're responsible for it.
so.
But we wouldn't have asked for it before because it was not in the contract before July of 24.
Okay, now we are in
Okay.
October, now we're dealing with this, I'm bringing this to your attention. Please make sure that you guys
What
take
is,
care of
what
it.
is the time frame on an SPQ? Is it forever? Have you ever had an insurance
Doesn't it
claim?
say-
No,
I think it
no,
says-
no, 5 years.
Yeah, 5
Yeah,
years.
yeah.
It says
but
5
I'm-
years.
yeah.
Right.
So okay, so here's what I see, that if one, I read it and it says, yep, I would have this form available from my buyer to the seller because I want the insurance information, right? So that they can talk to them. That's the way I see
So
it,
you
is that correct?
included in your,
Mhm.
you would automatically include this form in your offer then.
Not
to make
automatically,
sure. Well, yeah, because you don't, if they don't tell you, there's no way for you to know. So you could add this form and say, please respond. And if they say, no, I don't need to, there's no claims. Okay, great.
but they can sign something that says no
Right.
claims.
And then
So-
you have hard copy.
I agree
Good
with
idea.
Daryl
Yeah.
100%. Now he talks like me, exactly how I would do.
I don't talk like
You
you.
always talk like me. You always talk like me. So you always even speak in Russian like me.
Yeah.
With the same accent, with the same accent,
I-
Russian. By the way, do you like vodka?
I do, vodka.
You like vodka?
I do.
Me too.
You too? Because what happened, I brought vodka
Yeah.
to
Is it real Russian vodka?
a real Russian vodka, I brought it to Edgar.
Yeah,
And when he saw this bottle, Edgar, are you there? When he saw
There.
that bottle,
Yeah.
he was almost shocked because, you know, my husband always buys this size of vodka, so I'm
Yeah.
used to it. But Edgar was, do you remember Edgar how it was? Huh? So he said, no, I don't want that. And I since then I start thinking, do all men like vodka like
not
my husband?
necessarily. Did you check with JC? That's the question.
Yeah.
He did
Oh,
check with
okay.
JC, and JC said
Just to let
no.
you guys know, they're here, they're in the conference room.
Yeah, we,
They're just on mute.
Yeah.
They're just not talking.
So now I know that
They're not happy.
they do like vodka, alright, thank you. So let's keep going, So guys, as you can see, today is introduction to the offer, so I'm touching the points that are very, very important.
Yes,
Please,
we're
it's
looking
hard to
for,
talk
we're
about
looking,
it.
we're looking for Raymond, and I just figured out he's at the reception.
Okay, that's okay, let's keep going, alright, so ARC form is very familiar. Raymond, can you show us the ARC form again, please, very quickly?
Mute yourselves, guys.
So let's remind girls and boys
ARC.
what this forum looks about, what it is all about. You never used it?
I don't think I've ever.
No, I've never used it.
Yeah, so it's a good idea to start using it.
What's the title? Convey information.
ARC, authorization to receive and convey information. It's a really good
Oh,
forum.
I've used it, but not for.
Yeah,
Yeah.
so as you can see, you can request permission to talk to all these people. And whoever you want to talk to, you can request the permission upfront. And if you are giving the permission, you can talk to them. If you are not giving the permission, you cannot talk to them.
That's
Alright.
interesting, because it does, not just insurance, but, hang on, no, back up. So, government entity is a big one, homeowners association, that would be a big one. Then
Okay?
who else? That's it.
So
I mean-
the reason this forum was created, again, because of the lawsuit, and I guess you guys already learned by now from me that every forum we have, and we have 60 plus more forums just now added to our list because of the lawsuits. We don't like to use too many forums, but we have to protect us. You cannot call any of these people if you are on the buyer side without the permission. Remember that. You want, if you're on the seller side, if you're on the buyer side, you need permission, okay? So
That's
please.
interesting, because you're also talking inspectors, because normally in the listing, we'll get all the inspections, so technically, buyer's not supposed to talk to inspector unless this is signed. Also, where you going?
Wait, so I have a question about this then. Does
Wait a minute,
does
I'm
that?
not done, I'm not done.
Oh, sorry.
Move up. So inspector, HOA is a biggie, and I thought there was something else, but I can't see it now because it's down. Oh, utility, that would be your solar, right? So without this signature, so I can see where this is so important to submit with your offer, yeah.
Solar is covered in the RPA.
Yeah,
I don't care, well, it's,
But not.
you mean the authority for the buyer to talk to the solar company?
Yeah, they have to provide the lease or purchase
Well,
or
they
the
have to provide
documents.
it, but
They
then.
have to, yeah.
They don't have the
Not the
authority to talk to them. Here, I would put it there.
No, they do, because you have to either take over the lease or it's a sale item.
So
So
how,
the only time you need to talk to the lease company is if they talk to you to see if you're worthy of taking over the lease.
so again, let's not go into details, please, we need to keep going. You're right, everybody's right, I'm right. The thing of the matter is, that guys, know about the forum, use it with your offer, okay? Ask them to act on that, or vice versa, whatever, whoever you are, on which side you are.
okay, Raymond had a question. Go ahead, Raymond, we're listening.
Yeah, so does that mean on this form that you would send it to the seller and they would fill it out?
No,
Because they have to provide the information, right?
right, they would. Uh-huh. So
And
you're
if the
right.
seller said you can't talk to my HOA, then you'd have to kind of ask the seller, why not, right?
No,
No.
what we're talking, Raymond, that's a very good question. We're talking right now about this. We're talking about sending this form with an offer.
Yes, right.
Asking them upfront, being proactive, showing your buyer that you are better than the next agent. That what you're doing is above and beyond, that you're doing everything on behalf of the buyer. That's what you're trying to sell yourself.
Why would
Right,
we
so,
need to-
so this would come back complete.
Either that or
seller.
not,
Or
but at
not.
least you have done your job.
Got it.
That's all you need to show, that you have done your job.
But is it a requirement?
No,
It's
no,
not.
but it is on my checklist. And again, guys,
It's a proactive form.
it's, yes, and again, I want to make sure that you all understand, number one, that car forms are not required forms, except for agency, TDS, right? Those are several other forms disclosures. They are not required forms, guys. But this office will require them and is requiring them right now because we need to find the ways to protect ourselves. How in the world would I know without this form that I'm not as buyer's agent? I cannot go and call homeowners association if I have a question or my buyer have a question. How would I know that? I don't know that, but this is the legal way to do it right. and this is the right way to do it right. Yes.
So this form isn't exclusive to buyers, obviously.
No, no.
Yeah, so when I did this listing, I gave this form to my seller so that I had legal permission to talk
Yes,
to all
that's a
these
very
people.
good point, yes.
So, okay, in that case, did you check every box on there?
No, I just get pertinent ones.
Just the
How do you
ones.
know what's pertinent to the buyer?
No, I gave it to my seller.
It's
I
between
know, but how do you
them.
know what the buyer wants?
I wasn't the buyer's agent.
Okay, I get that. Good.
You gave it to the seller so that you could disclose it
Wait
to
a
the buyer.
Yeah,
right?
I'm just saying this form isn't exclusive to the buyer or the seller. is my
Right.
point.
Well, Daryl's
It's
point is, when you
designed for
gave
the
it to the
buyer, but
seller.
if, yes, it is.
Okay,
But
let's
if you-
read,
but
Raymond, can you go
It is
to the
designed
top,
for a
please?
buyer or seller.
Yes.
What does it say? Authorization to receive and convey information, okay? So it doesn't say, is it safe for the buyers? Including everyone. See, broker associate, employees, this,
And it says the collectively, broker represents me as quote, seller or buyer in the sale.
okay,
I can be used either way.
so I think Raymond asked a good question. Now, what we are dealing with this form right now is this, guys. We can do it as a seller's agent between me and the seller. Connie is my seller, right?
Right.
We can do between us. Now, I have a buyer, and the buyer does not know about this form, right?
Right.
I know about this form. Now we are talking about not me and the buyer, but buyer and seller. It's their contract. So it's between them, and on behalf of the buyer, I can submit a brand new form.
Correct.
Brand new form I can submit and ask for permission.
Yeah, because the seller's gonna fill out current insurance provider and the buyer's gonna fill out prospective insurance provider.
Buyer is sending the form blank.
Yeah, it should be, yeah.
He's sending it blank. He doesn't know anything. He just asking.
The seller's not gonna know the
Why
perspective.
does the buyer care about putting perspective? We don't care about that.
Yeah. He will
Or
mark
is
the
insurance.
Then why
ones
is
he
it
wants
on
to
there?
talk. I want
I
to
don't
talk to
know. Ask
homeowners, for example. I want to talk to homeowners, I'll mark homeowners and things like that.
Okay, so if I'm the seller, I wanna know who their prospective insurance provider is, because I wanna know for sure that they can get insurance on this property. Especially the house that Z just sold.
Correct, I would want to know, I get that question all the time, I mean, you know.
Okay,
because
guys,
Who's the current insurance provider so that they can go to that
Okay,
insurance
all right,
provider and say,
that's-
all right.
you are all right. We are all right.
Okay,
We're
moving
all
along.
right. There is no wrong person here. Anything wrong,
See,
but
you
it
didn't ask
depends
for-
on the circumstances.
We
We'll
all
deal
get
with
A's.
them.
We all
We'll
get A's.
deal with them once they come in. It's not the point. The point is there is a form and it's a good idea to use it. That's what it is.
On
Yeah,
both
next,
ends.
next.
Let's keep going.
Yeah.
Okay, next one. Let's go back, Raymond, please, let's go back to the next one, which is fiduciary duty compliance. We talked about it at length. I'm not going to go through this, but this is very important that you guys remember what your fiduciary duties are. That's number one, that you work in the best interest of your clients, meaning that you research, you search, you follow up, you communicate, you negotiate, you do everything possible that you are allowed to do within your license. Please go back to that one, please, just 1 second. Please go back to that, yes, thank you. So fiduciary duty, it's a huge responsibility. So please make sure that you know them and you apply and you comply with them. Next, real estate laws, DRE rules and regulations compliance. So we are talking about real estate laws, DRE compliance every single time. I want to show you something very quickly. Go ahead, please go to the DRE document you just opened, Raymond. Yes, this one. And go to, move up please to 481, I believe. So this is the, keep going down a little bit, please. No, I put
Oh,
here. No, I gave you the page number. Can you go to that page number, please? 481, please go there. And, yeah. 481. Okay, that's it. So, guys, I don't know if you see that from here, but the reason I brought it up, because DRE requires, thank you very much. DRE requires the full correct name, right? DRE requires description of the property price, property address. We don't need to go through all this. This is very clear to us. But the reason I brought it up, that's what I require to see when I get the contract. Every single point, that's my point. Every single point is required by law and by the DRE. Do you understand? When you miss any of this, we are not in compliance. That's why it's so important. That's why maybe somebody is upset that I am so diligent on to the T, so to say. But this is what I'm trying to show you. It's required, guys.
Can you scroll down on this?
Hang on, the description of the property, that's many times is, the APN is not in there, and that is very important, it's right on the listing,
Purchase
not on
price.
part.
Yes,
You know,
yes.
property
See,
profile.
again, they do require that. Everything that I'm asking you, I've been through this through years, through training, and I know it's required. That's why I ask you. And another thing, purchase price. I recently saw this. I recently saw it in the files, to be determined. It's for listing agreement, for purchase, to be determined. So there is no in the world place for the words to be like that, to be determined.
But again, if you haven't, you're saying that you don't even write the contract unless you know
Yes,
exactly what the
yes.
purchase price is.
Everything should be, this is what the requirement for the contract, purchase contract.
So what would you do if you wanted to start working, you have to wait till the contract is signed to do any work, right?
Then you work on the wall, on the house.
On the house with the person or whatever, you're assuming you're gonna get the listing. And you just haven't determined the purchase price yet.
No, the price is decided upfront with the seller. That's been like that, this is right now. You do not put in the contract to be determined, you put the price can change, you can modify.
Yeah, I think that's the answer.
That's the answer, you can
So
always
you
modify.
put
Yeah,
a price,
Yeah,
then all of your inspections come in and you can
you can
change.
do whatever you want later.
Got it.
But this is the con, once it's signed, and the auditor just knock on the door, comes in, pulls your this one and says, what is it? To be determined, what is it?
I'm sorry.
Yeah, so
Yes,
that's
I'm
why.
guilty,
No,
sorry.
that's all right,
Okay,
that's okay.
I did it.
but you could modify, there's something there.
So Kanye agrees, she just
Yeah.
sneezed. She agreed. So, all right, let's keep going. You understand that, right?
Yes,
That everything on this paper, what you touch, is required legally. If it's there, it's required. All right, let's keep going. Next one. Legal issues. So let's continue to the next one, legal issues. Hold on, please, hold on. I missed two, I forgot. Office policies and procedures compliance, guys, office policies and procedures, we talked about that. Margaret, when we have the system, our own resource center for this company, we'll have office policies and procedures there, okay? So it should be so visible to everyone, every time, that's the DRA requirement, so we need to have it there. So when you see office policies and procedures, and you will see that certain number of documents has to be there, it has to be there, you have to oblige, you have to really follow this list, okay? Narco, the ethics compliance, you all know that, I don't need to keep repeating, but this is very important. Keep going, let's keep going. Legal issues, rejecting a buyer's offer for the wrong reason. Be very careful, once you work with the sellers, why the seller rejects the offer. Be very careful, be aware of that, because later you may get a claim that it was discrimination, right? So if somebody, that's why what I always suggest when you represent the seller, do not, please explain to seller that it's much better if you handle that. If the seller does not speak directly to the buyer, or buyer does not speak directly to the seller, because who knows, maybe they will not like my accent, maybe they will not like my skin color, maybe they will not like this and that, right? So maybe they don't like plump people, who knows, I'm pretty and plump, but they don't like it, so who knows? So that's why, that's one of the things that we need to make sure that we kind of, do you understand my point? That we prevent that and say, you do not communicate, I represent you, I will do all communications, okay? Sometimes people take their clients to present offers in person, I don't like that, again, for all those reasons. It's very, very important, right? So eliminate the connection with the seller buyer as much as possible. Violation of the, so again, the example is violation of the Federal Housing Act and similar state laws making it unlawful to discriminate. So we all know that. Is it happening in real life? All the time, guys, it does happen. Somebody doesn't like somebody's, somebody's race or something else, or yeah, so all the time it happens. So you don't need to be in the middle of it. Okay, not acting in good faith, like I said, it's a legal term. Here is a list of what's considered illegal or unethical. It's very important to understand that unethical and unlawful conduct is more than just these words. It's really it has a lot to it. We will talk later about it. Lack of truthful and complete information. That's another thing. That again, the information must be truthful. We know we must say the truth, but the truth may be as a result of us. You may lose a deal because, so we need to make sure that whatever we say is based on the facts. Two things we need to remember when we talk. Two things, guys, remember for life. One is when you talk to someone, reference the facts that you are describing. Reference them. Tell where you got that information. Okay, that's number one. Second one is a good thing to say and write. In my opinion, these several words can be a big deal when you are defending yourself. Okay, so if you write, in my opinion, so this is your opinion, it's not a fact you're stating. So this is a very powerful words that will really help you. Okay, I got this from Jen, it's not me. False, misleading, and deceptive information. One of the things that everyone should really understand, that never, ever, under no circumstances, you do this. You do not provide any of this. Double check, research, make sure it's in writing. When you represent a seller, you use his TDS, his SPQ, and use it and have it in front of you all the time, because you're getting questions on the phone, for example. Have it in front of you. Use the information and say, this is what I have on SPQ. That's what I have on TDS. I'm passing the information. So consider yourself as not a decision maker, but a passer, I think, of the information. That's who you are, not a decision maker. All right, non-disclosure, that's another biggie, right? We all know that we must disclose. All right, so fraudulent schemes and offers, guys, it's unbelievable. If you go to the DRE website and look for their list of people who are being under investigation or being investigated right now, it's unbelievable what these people done. Unbelievable. So you can read the whole list of them. And please make sure that nothing is done under the table. And of course, like I said, the information must be correct and proper. Okay? Okay, keep going.
Do you need water?
Thank you.
Yeah, only it's all easy.
Okay. Keep going.
Keep going, Raymond. Non-cooperation, okay.
Guys, I want to say something about that.
Non-cooperation,
Maybe we get some water first.
yeah.
Thank you so much.
I think I still have something.
Been there. Too many times, usually when I'm singing in the choir. No, thank you.
Okay, guys, cooperation is very important, right? We all know that. So if you feel, oh, this is how I feel. I send you email. When I send you email, I have something important, right? Because I contacted you. If I don't get an answer, how do you feel? If you said something important and you never get an answer? Bad, huh? Really bad. So cooperation is very important. It can make or break a deal, really. So that's why they say work with another agent, be professional. Professionalism is very important. You are not on the flea market. You are really, flea market is the place we all know they can argue, they can bargain. This is a professional environment. When you go to the doctor, you expect that. So please make sure that you're cooperating on a very high professional level. I heard people talking from this group. I heard Edgar talking to other people. Very nice, very professional. Really heard him more than anyone else. I was in the office. Very professional, right, Edgar?
Yes, but he's muted. Talk to us.
Unprofessional.
Okay, thumbs up. Thumbs up.
Very professional. I like that. I heard other people, not from this office. I heard other people, other agents, so unprofessional, so abrupt, so rude. Do not give anyone an impression that you are in a hurry. That's the worst thing you can do, right? You are not, I'm in a hurry. Okay, that's it? Let's go, or something like that. Do not do that. Do you have any other questions I may answer? That's the good way to end up, right? How can I help you further? Is there anything else I can help you with? Something like that, but this should be very important. Next, offer confidentiality issues. All right, this is one of the issues that we all have, and we need to talk about it. Because of course I was not able to cover everything, but something in the offer that you should really be aware of. Okay, can someone read it for me, please?
Sure. On the Code of Ethics, Standard of Practice 1-9, the obligation of realtors to preserve confidential information as defined by state law, provided by their clients during any agency relationship or non-agency relationship recognized by law, continues after termination of agency relationships or any non-agency relationships recognized by law. So what does that mean? That
Means don't
means.
throw your files away in an unprofessional way.
No, that's
So-
actually, no.
So,
It means that, after you close escrow and something else comes back, you can't bad talk. You
it's not
can't
only
leak
that,
any
it's not only
information,
that.
but I
It's a
think
lot of
that's.
things.
It's a lot of things.
Yeah.
One of the things which really common, in my opinion, really common, and we need to be aware of that. Let's say in a year after you close the escrow, you got a call from another agent who says, you know, I'm working with this person who you were selling for before. Now I'm selling his home. Here's what I need to know from you. So be careful what you're telling. That's a good example. That happens quite a lot, actually. Okay, so please make sure that you remember confidentiality survives the termination of agency.
Well, the biggest breach I ever saw was when we worked for Remax. And I went out to the dumpster one day to throw something away, Lord knows. And there were boxes of files, old files that had just been thrown in the dumpster.
Yeah, you
Social
can go there.
security numbers,
You can
all
go
of
there.
this information,
I have social security then, because back then we had the loan apps and all that in there.
all that
Yeah.
was in there.
Yeah.
So who was the culprit?
I don't know exactly.
Okay,
I just
so
looked that close.
you're right.
I'm
So
curious.
be careful about your files, be careful what you do with information. It's very important. Confidentiality survives the agency termination. Okay, keep reading, please.
Go ahead. Oh, she's not feeling good. Go ahead.
Realtors shall not knowingly during or following the termination of professional relationship with their clients, 1, reveal confidential information of the clients, or 2, use confidential information of the clients to disadvantage of the clients, or 3, use confidential information of the clients for the realtor's advantage or the advantage of third parties unless A, clients consent after full disclosure, B, realtors are required by court order. Oh, he moved.
Or C, yeah, it is the intention of a client to commit a crime and the information is necessary to prevent a crime. Or
D, it is necessary to defend a realtor or a realtor's employees or associates against an accused wrongful conduct. Information concerning latent material defects is not considered confidential information under this code of ethics adopted January of 1993, amended January of 2001. Sports car.
Okay,
wait a
hold
minute.
on, please, hold
Hold
on.
on, yeah.
Hold on. Let's go back to number
Commissioner
one
started.
again. Let's go through them line by line again. So you cannot reveal, number one, you cannot reveal confidential information of clients, right?
Right.
So confidential information is a very broad kind of broad meaning. What I consider confidential, you may not. So one of the ways to prevent a failure in this particular area is to ask your seller or your buyer what they consider, and we'll talk later about that as well, it's right here, what is they don't want to reveal. So that's every time you have a new seller, new buyer, that's you need to ask, what is it?
Because, so the question is, why are they moving? You're saying to
Well, that's a
ask
big
them,
one.
Yes.
may I tell them why you're moving?
Yes,
Or would
yes,
you like to
yes.
keep that confidential?
Yes, so what we need to do is to create a list and this questionnaire,
Infinite.
like a questionnaire that's always with you. I think it's a good idea, and they just need to yes or no.
Should we tell them the price is flexible?
So, yeah,
When you go up a little bit, I think there's a state requirement, keep going up.
The obligation to pursue.
State law, as defined by state law, to preserve confidential. So if you want a definition of what that might be, there is a state law that describes things that are confidential in a typical real estate transaction. Doesn't cover everything.
well, this particular document, which is Code of Ethics, does not describe, that's why we need.
Oh, it says you can
But it
read it
refers to
though.
the state law.
Okay, yeah.
Very good.
Next, number 2.
No, go back to number 2.
Raymond.
There we go.
Okay.
It's clear, right?
Clean it up
Oh,
there.
okay, so number 2 is you cannot knowingly, a realtor, use confidential information of clients to the disadvantage of the clients. So, I mean, I know a good example of that is you do not announce to any agent that calls you or at tour, my sellers are very motivated.
They will consider all offers.
That's a disadvantage for them.
But-
Well, it's not because it puts them in a more difficult way of negotiating. I mean, your duty is to get them really the best price you can, if that's what they want.
Right.
So,
But I always ask another agent, is there flexibility in the price? And I almost always get an answer of, yeah, there's some flexibility there.
Well, that depends if it's confidential information, right? Or is that considered confidential information?
So we need to find out what the law says about that.
Right.
But one of the things that I think that happens quite often about this, use confidential information of clients for real disadvantage. Okay, for example, if you say, if this is what may happen, if you say you represent the seller and the buyer come in and they say, if you buy from me, I will get you the better deal. Right? That's not good, right? That's not good to say.
Because you can also have consent from the seller or your client to disclose that information.
Right. We will talk about it in a second. So let's move on, please. So now we understand that what we should do, we should not be doing. Okay, keep going, please. All right, information concerning, okay, we talked about that. Yeah, let's open this forum. This is the forum that we need to
CND.
know about, CND.
Confidential.
It's on our list. And I believe we talked about it. Okay, very good. So let's read it first. It's very important form, actually. Can you, can someone read it, please?
Go ahead, Raymond, because we can't see the whole thing. Oh, there it is.
In the absence of an agreement to the contrary, the existence of an offer and the terms and conditions of an offer are not confidential. Paragraph E8 in the statewide buyer and seller advisory.
Whoa, slow down.
Hold on, please. Let's make sure that we understand that. In the absence of an agreement, again, if you don't have the existence of an offer and the terms are not confidential. So if somebody calls you and asks you, what are the terms? What's the price you got? You need to tell them. You cannot say, I cannot say. If you say, I cannot say that, then you need to say, I have seller's instructions not to
Yes,
say
and
that.
the answer is the seller has instructed me not to share that.
Yeah, exactly.
And you have to have it in writing.
You have to have it in writing.
And generally, most agents do not know this.
They don't know.
They don't know this
99%
yeah.
is saying no,
Yeah.
okay? Keep going very slow, please, slower. Raymond, please.
Paragraph E8 in the statewide buyer and seller advisory, CAR form SBSA informs buyer and seller of this reality. If the buyer wants to keep the offer or its terms confidential, the buyer must first obtain the seller's agreement. Form CND is used to create a mutual agreement to keep the offer or its terms confidential.
We'll see it right now in a second.
All right. So
Do you
in our
understand this,
offer,
That's clear?
we include this form in our offer. We want to keep it
That's why I
confidential.
added to the list. Now you understand why,
Yeah.
okay? Keep going, please.
Keep going. Paragraph 1 states that if the CND is provided before the RPA, the parties are not obligated to sign the RPA, but each party is responsible for any breach of the CND committed by its agent.
How interesting.
Mhm.
This is amazing. We didn't know that. I didn't know that until I read that. So let's read it again. Where is it?
Paragraph.
Paragraph
yeah.
1.
Yeah, see what
Yeah.
it says? That the parties, the CND, if CND is provided before the contract, meaning even before you submit an offer. How interesting, Kanye, you need to read that. You need to see that. So if the confidentiality in form CND is provided before you submit an offer, see that? Paragraph 1 states, if the CND is provided before the RPA, the parties are not obligated to sign it.
But they're committed to the CND.
So the question is,
Okay, we have questions
Yeah.
back there. They don't understand. They don't
I don't understand it, actually.
So, yeah, what it's saying is if you're gonna write an offer, but you might have it, but you're gonna submit the CND
first,
first. If the seller signs that, but later you send the offer and they don't accept the offer and you don't have a contract, they're still committed to the CND. They still cannot disclose what your terms of your offer was.
Oh, okay, you're saying they can't disclose it.
so the question is, in my mind, the question is, how important this is for the buyer, right? If the buyer says it's not really important to me, and that's what you have an option.
Sometimes you'll say, well, my seller didn't accept an offer of $1 million. You better make sure you've covered your tail on that. before
Yeah.
you
Well, I
ever
thought
say
you
something.
had to disclose if someone asked, if Nate said, hey, what are your offers coming at?
Back up. If they have submitted a form that says, and your seller agrees to hold their offer confidential, then you cannot.
Yeah, same.
This is a new thing.
Yeah, I can give you an example.
Two different, wait a minute, hang on, let's get Desiree straight. So, she's great.
I'm all crooked right now.
Yeah, straighten up Desiree, so before we introduce something else. So the first one was, there's no confidential agreement here, confidentiality agreement. There's nothing in that. and you've received offers and you get a call and they ask you, well, how much is it? What were the terms? Then the agent should be given that information out. If the seller hasn't once signed anything and the buyer hasn't signed a non-disclosure. Okay,
Once that's signed and.
yeah,
I
so if the,
only if it's in the interest of your buyer or seller.
so if the seller, seller's agent, listing agent, you're representing the buyer, listing agent, and you are curious about what the other offers are. And the agent says, I can't disclose that. Oh, do you have that in writing? Did your seller,
Sign the CND.
or not to disclose? Fine, then they don't disclose, right, if they did sign it. Doesn't mean they're going to share it, even though you tell them that, they
Yeah.
still won't.
Exactly. My fiduciary responsibility to my seller is to tell you, yes, I have offers. I don't have to tell you that the offers are $100,000 less than list price.
Okay, but I know
Well,
before-
if she asks you what the offer are,
In the fiduciary responsibility to my seller, I would not answer.
If there's.
But you
no-
have to.
You have to.
Yeah,
There's no
This is
like
law, this is.
That's why I'm confused, you do have to, unless that's more of a sign.
unless you're signed
That's-
for.
Can-
This is not law, this is ethics, number one.
No,
Two,
this is
I know.
law for ethics
if you
law.
sign a CND, confidential non-disclosure,
Mhm.
Yes.
before you do the offer, we do this in commercial all the time. In fact, step one,
Right.
I just had it yesterday. The step one, when people go and see my stuff online about the property, they, in order to get the details of the property and go to the next step, they have to sign a non-disclosure. And the reason is, there's a lot of details that
Right,
you agree
right,
to,
right.
you don't want the community to
This
know
is a
about.
good
because
thing.
It can
This is a
change
good
the
thing.
offer.
So Raymond, can you do me a favor, please? Can you go to the top? I want to show just Connie, she probably was in the bathroom at the time. In the absence of the agreement to the contrary, the existence of an offer and the terms and conditions of an offer are not confidential. So when you say no without sellers, permission to do that, or buyer's permission, sellers or buyers, I don't know, whoever, then you're
That's
not.
not in the best
No,
interest of my
yeah.
seller.
Correct.
And I'm not working in a good faithful relationship to my seller.
In
No.
her in her determination, it's not in our relationship with the buyer. It is, we believe it's our fiduciary relationship to our client to not reveal those things. You
So
can
why don't
treat
you have the
everybody,
seller sign a CND?
Yeah, so you should always have your seller sign it.
And I would.
Yeah,
no,
Raymond is correct, always do that. And then it's not your decision, it's seller's decision, it's between seller and buyer, not you.
And if I tell my seller, we got an offer, it's $100,000 less, do you want me to tell everybody that you got $100,000
No,
less?
No.
Say no.
Hang on a second.
No, you are.
Why don't you have your seller sign a thing that says, I don't want you to disclose? Why
'Cause
don't
then you
you
could blame
keep it
the seller.
confidential?
Well, we can.
There you
I
go, then
haven't,
you're
I
covered,
haven't
then you're
needed
covered.
to.
Guys, let me make it very clear. If we don't follow the right path, the attorney will be able to prove that you were not working one way or the other, if you don't have that. They will prove that you were not acting in the best interest of the client. Do you understand? They will prove it one way or the other. No matter what you think, no matter what he thinks, I think, they will prove it. You're not acting. This is the only way. Let's go to CND form, please. Now let's go to the form itself.
Well, it certainly sounds like your fiduciary responsibility is to discuss with your seller or buyer
Right.
whether they want confidentiality
Yeah,
or not.
yeah.
Well, also too, what if if that's not signed, and let's say someone asks, oh, I got an offer, and well, yeah, this offer came in 50,000 over. That's actually gonna be working for the seller, because then the seller will be like, then that person realizes, okay, I gotta beat that offer, which means the seller's gonna get more money. So it's not necessarily against the seller either.
Not
Actually, that's what
necessarily.
attorneys say, that it is good for the seller to disclose the offers.
Right,
That's what attorneys told me.
but now you have this option to where if
Yeah,
it's signed. you
yeah,
don't
it's an
have
option,
to.
but it's their
Well,
option.
if they sign the non-confidentiality,
can't.
then you can't
Yes.
say that.
And you can
You
change-
can only say you've
you can-
received an offer
Now,
that's
do I
over
have
this
to send
price.
this to them?
So it might work
Right away.
against you. cited the
Is
form.
this an absolute, I have to send this to the seller first?
So if I don't send this to the
Yeah.
seller, then I use my own discretion as to what is in his benefit and
No,
what's not.
you're not supposed to,
You
it's
cannot
not your
do that.
choice.
It's right there.
But that's
And
the
here's
whole
the
idea of
thing.
being an agent.
No.
It's a standard
No.
practice. You don't have.
It's
Fiduciary,
still
your fiduciary relationship to your client is primary.
Right.
This is something that you can sign with the buyer or seller to, if you do it early, like Z did, you can say, here, it's all available. I'm able to share with you up front. If you don't, the buyer can fill this out and say, I need this info. And you have to disclose it.
So
You sign
this,
it.
yeah, you're right, everybody's right, so Kagi, you are thinking, please forgive me, but this is an old way of thinking.
Well, that's because I'm old.
You're
Well, yeah, better.
you are wiser, you are smarter, you are more beautiful,
I
but not old.
I think in the process of if I was the seller, how would I handle this? And if she's coming in $50,000 over this price, I might disclose that, but probably not. I would tell
It's
another
not your
agent.
decision,
Exactly.
it's not your decision,
So in
that's what I
that
keep
light,
saying.
well, but we make decisions all the time. Because we know much more than what our clients and sellers.
You don't make a
To Connie's
decision.
point, can you modify it? Could your seller modify it? So
Yes.
you start the whole process and the seller says, no, I don't want you telling me.
I'm
You get a month into it, could the
yeah.
seller modify it?
You can, but
You
you
know.
better have it in written form somewhere.
Okay, you can, but not until the buyer, once they are in contract, that will be hard. So, so this is the form, take a look at it, please, very quickly.
I have a quick question.
Yeah,
Yes, can I use this form instead of the NDA?
NDA.
NDA, can you tell me, remind me what it is?
An NDA
It
is
is
a
an
non-disclosure agreement. He has another.
Non-disclosure agreement.
Yes, non-disclosure agree, yes, that's two separate forms, yes, yes.
What's the difference?
I need to see them, you can, you can use both. I can see, I can think, but I need to see.
Daryl, what do you think?
Yeah, this covers two things.
That's right.
Information disclosure that you may consider private, and then it also is a non-disclosure of other documents. So on that form, you're gonna say, check the boxes and you provide this information. This one covers more.
Yeah, this was kind of a blanket, so
Yeah.
I think this is the, yes, I guess.
We will take a look at the other one that Edgar just mentioned and we will compare. Let's go through this first. So we have here confidentiality and it says whatever it says, right? It's really a good thing, actually, I like it. And then keep going, Raymond, please, slow, yeah. And then we have confidential, it tells you exactly what is confidential in seller's view.
Well, there you go, you got
So if
offering
I'm
price.
representing a buyer and I use this, which is what you're recommending, they cannot disclose to her what my offer was. They can
Correct.
only disclose, because
Correct,
in cooperation with other agents, they can only disclose that they have an offer.
correct.
Okay. That I like.
Good, so this,
Yay!
But I know that's been contentious.
so this is very good example of how to properly handle that particular issue, because it becomes an issue, that's why we had lawsuits, that's why we have this forum. So guys, please take it very seriously. I know nobody's doing that, but because you don't have the training like this, no one else has that. So please.
No absolutes.
So, so please, Raymond, can you show us the other form, the Edgar just mentioned?
The NDA.
NDA.
I've got to pull up car forms for that because I didn't pre-download.
That's right, no, let's not do it, we'll do it next time. Okay, I promise you, Edgar, we'll take a look at both forms next time.
You wanna make a note?
Yeah, thank you. So, so let's go back to that description, that car publication, please. Yeah, this one, and let's do this. We covered quite a bit here, let's finish it. Let's finish this one. Go up a little bit, I want to see, we need go up a little bit, please. So, yeah, let's start with.
I think
this
we
one.
left off here at paragraph 2.
Okay, go ahead, please.
Paragraph 2 identifies the terms which will be confidential. These can include the one of the parties' names, the offering price, offer terms, or other items specified. If C and D is important to a buyer, then the form should be provided to the seller before the buyer even makes an offer. If not, then the C and D should at least be attached to the buyer's offer if the seller signs along with an acceptance or counteroffer. Then the buyer's offer or terms remain private. If, however, a seller decides not to sign the C and D, the seller is not bound to contractually keep the information confidential. That is a risk a buyer takes by not waiting to submit an offer until after the C and D is signed.
So
Send it.
guys, so that's why I brought it up today, because nobody really pays attention. And I tried to bring it to your attention today, things that we never talk about. So this is, it will be also on our resource center. And this is all you can just send to your clients. This is what you will be able to send to them, to educate them, to prepare them. You don't need to talk much.
Okay, so I have a question.
Yes,
Most of the transactions we're doing now are multiple offers. And you send all this stuff in, they want the cover page for all the inspections signed and all that. So we send this in and we hold the contract back, they may never contact us again.
either that or not, because they don't look. If they are agents like a lot of, I know, they don't look at anything, they just look at the offer itself. And they just send DocuSign to the seller, everything, to the buyer, everything. That's what it is.
So how do we protect our buyer?
So, well, you
Typically, you do this in
explain,
advance.
yeah, you explain in advance and you say what may happen, you give them options, you're not a decision maker. You do not say, this is what I want you to do, this is what I will do.
So I say, my buyer would like to submit an offer, however, we would like to keep the information confidential. Is your seller okay with that? And
Don't
they're gonna,
even go into that upfront, don't discuss, just do
but you
it.
just said if we don't go into it up front,
Not
then
with
they
the
can disclose
agent.
an offer.
With the agent, don't do that.
Send them the document,
Yeah, don't
send them.
talk less, talk
And
less.
so,
If
I
your
mean,
buyer is sensitive to their confidential information
Yeah,
being shared,
that's all.
we do this in advance.
right, and send it to the agent and
Yeah.
say, my buyer.
If they don't like
wishes
it,
If you want
don't
to,
buy. But if you-
they say submit it with the offer, submit it, don't do it upfront. Submit it with the offer, hoping that seller will sign whatever it comes his way.
They just said, if he doesn't sign it, then they can disclose whatever's in the offer.
That's right, but that's why we're telling you, honey, please provide this document to your client first.
My
You
client
don't
first, but
deal
then
with
it
the
has to
other.
go, I'm talking, we're
If
talking
you need
multiple
an-
offer situations.
Yes. Yes.
If you need an agreement, on this, you must get it in advance, or anything you give the seller can be revealed.
Disclosed.
So, get this first. If you know you're gonna, and there's an offer date where multiple offers come in on the 15th, on the 13th, you should have this done.
I'm surprised a lot of these investors, these flippers, they don't use these forms, I'm actually surprised.
And I do just want to point something out that, if you send this first, this is something that could, impact the seller in you choosing your offer. So you have to make that known to your buyer.
Yeah, it's
Yeah,
their
but the risk you
option
take.
that they may really lose the deal because of one document that they don't want to sign.
Mhm.
So like with any other documents, and that's the decision your buyer makes. That's what I'm saying.
You're gonna go higher.
Yes, yes,
I-
yes.
Okay.
See, arm was tired.
Okay, so am I correct, Connie, that your question was, what if the seller doesn't sign it? Then what? What's that?
It's up to the buyer,
Yeah,
either
that's
they
So
agree.
then your buyer decides whether or
Yeah,
not to
whether they
submit it without it.
move on
Okay.
or without it,
Got it.
yes.
It's their
Well, but I
decision.
think it's the timing too.
That was my
If it
question
goes
also.
in with the offer and they don't sign it, you're vulnerable.
Then the decision's been made. Your buyer doesn't have,
But
doesn't
that's
get that choice.
why you have to explain it to them.
Yeah, those documents, you will say another one that we have, you say, you explain the form, that's, we got a lot of dollars back when we closed the deal. It's a tough job, but one of the fiduciary duties is to explain to people.
I just think of all the times that I have rushed to put together an RFP
Right,
to get to the seller in time.
right.
And now there's gonna be an extra step.
when
And
you
my
work,
buyer
when
was-
you work with the buyer, you do have time, because it's not happening overnight. That particular property maybe, but you work with the buyer for some time, do a lot of work upfront, send all this to them. Have a list of things that they need to finalize with you.
So many times I've called the listing agent and they've said, oh yeah, we've already received 3 offers, we're in the counter offer stage, how do you want to do this? My buyer says, I don't want my offer.
Well, but that's what you share that information with your buyer, it's still your buyer's
But,
decision.
Yeah.
Do they wanna compete, do they
Yeah.
want their, you know?
That's what I'm saying, that Connie, this is, this is the burden most agents put on their shoulders. They feel that because they represent someone, they have to make decisions for them, and you know.
Oh, no, not on this one.
But,
This one I
but please, make sure that you do your job. Sometimes it may happen that you lose the deal.
But when we're explaining this to a buyer, we need to make sure that they
Yes,
understand that
yes,
by signing this, you
Yes.
could have just condemned your own.
yes, and you say that. Okay, guys, is that clear so far?
It's just like
I'm
the
okay.
seller, if you don't pay the buyer, it's broker,
go
you're
back
probably
to
gonna
this
lose
again.
it,
It's just introduction.
the
first.
deal.
So, because it's a lot of stuff. All right, Raymond, let's keep going. What do we have next?
Hey, we're having fun.
Offer presentation. Oh, that's another issue. Presentation of the offers. Raymond, go ahead, read it. You have such a nice voice.
All right, standards of practice 1 through 7. When acting as listing brokers, realtors shall continue to submit to the seller, landlord, all offers and counter offers until closing or execution of a lease, unless the seller landlord has waived this obligation in writing. Upon the written request of a cooperating broker who submits an offer to the listing broker shall provide as soon as practical a written affirmation to the cooperating broker stating that the offer has been submitted to the seller/landlord, or a written notification that the seller has waived the obligation to have the offer presented.
So guys, let's do it again in a little bit slow motion. The key thing here is the first one. When acting as a listing broker, you shall continue to submit. We know that, right?
Yeah,
Until closing or execution of a lease. Okay. we
But this
all
is
know
a
that.
lease, so I think you have to.
No,
Sale or
lease.
It says seller or landlord.
Yeah, seller landlord, it's combined, but we'll look at the seller right now, because waive this obligation in writing. So again, seller needs to give you instructions.
Right.
Second one, upon the written request of cooperating, that's biggie. We have it quite a lot that's happening, and nobody's doing it right, as far as I know. So upon the written request of a cooperating broker who submits an offer to the listing agent, the listing broker shall provide, as soon as practical, a written affirmation to the cooperating broker stating that the offer has been submitted to the seller, a written notification that the seller has waived the obligation, and I would add to this one, we need the date the offer was submitted and signed by the agent, or both seller. That's the key. That's the key that no one is doing, right? So you have a situation with multiple offers, your offer was not accepted. You may have a thank you for your offer email, or may have a phone call, or you most likely will have nothing. And then your client is upset, and you say, listen, I will do that, no one will do that, because I follow the code of ethics, and you show this to him, to your client, and you will say, this is what I need from you according to the code of ethics, and you put the title of this article. So that's why I brought it to your attention, because when this happens, at least you are really equipped now with the right action. So you don't call him, leaving him a nasty message or arguing with him. You don't do that. You put together an email copying your client saying, according to this article of Code of Ethics, you're supposed to give me A, B, C, D, E, and I request that immediately. Something like that. Okay?
So the actual contract form has a spot where, when was this offer presented,
Right.
and that, you should be asking for that page back.
Either that, or just reply to it. Because in fact, talking about that particular page, talking about the particular, which we will be talking about it. But you can see it at the very bottom, right? We all know it's at the very bottom, right?
Right.
So, it's not legally required. You know that, right? It's not, you know that, right, guys? That it's not legally or legally, it's not required for them to return this to you. Ethically, it is required, as we can see now. That's a big difference.
Yeah, but it's a clean way to satisfy this paragraph, is to get a copy of this.
Yep.
So you've asked for, then you know if you see that signature on that form, that offer has been presented.
Yeah.
And that's the secure part of this thing.
Of course, you can request that or answer my
And they may
email.
not do it,
Yeah.
but typically
Yeah.
they do.
Again, please understand that you are you. You are responsible for your action, not somebody else's action, except for your broker. Broker is responsible for everybody's actions. So in my opinion, that's how I work. I do everything that I'm supposed to do. I don't think will I hurt his feelings? Will I do this? Will I do that? You know, I don't do that. I just need to do it, I do it. It's like a surgeon. Surgeon need to cut and they cut. It's painful, but they do that. So that's how I look at it.
But the timing of the presentation of the offer should also be written. In other words, you're
Yeah.
gonna do
Yeah.
this one at a
Oh, I think they
time
do.
as they come in.
Yeah.
Where is that?
It's right here.
Well, did
Very
they
bottom.
present?
Well, even you have to be able to tell the other agent, I'm gonna wait until
Oh.
noon on Friday.
Yeah,
And then
yeah,
there-
yeah,
But
Yeah.
that's like maybe on the MLS or wherever you have that.
yeah.
That's when you may present, this is the confirmation that it was
You're right,
presented.
you're right. It's a
Exactly.
good contract. That's why they added that because of so many issues with him.
Yep, that's why, exactly why they added it to it.
We didn't have that before, but
Yeah.
they added it because it's impossible. People are not professionals. They do not act like professionals, unfortunately. I don't know why, but that's what
But
it
I'm
is.
just saying, you better have it in writing somewhere that you're gonna wait until Friday at
Yes,
noon
yes,
to
that's what I
present the
said.
offer. Because if this offer came in on Wednesday, you have to make sure that you have it in
You're
writing,
absolutely
you're
right.
waiting until Friday.
You're absolutely right. That's why I suggest to put email, send email copy of your client and ask, by this day, I would expect you to submit that. All right, thank you. All right, let's move on. Okay, offer presentation. Have we done that? Oh, we just talked about that.
So it's a counter offer.
Okay. Upon the request of the listed broker who submits, okay, we talked about that. Okay, so if you have something else according to this, again, it will be on our resource center, you'll be able to get to it. Next, buyer's offer. Now, we talked about quite a bit, now let's talk in more details. So we already discussed that in the past. What can happen to buyer's offer? It can expire, can be rejected, withdrawn, ignored,
Ignored.
counted, right?
Which makes it expire.
That's counted. And all this are very important to handle properly, would you agree? Yes, and we do not handle it properly, we don't do proper things. So let's talk about expire. We talked about that before at length actually. If the offer is expired right now, today at 12, and 12:15, you got a call from the buyer's agent saying, we are going forward with this offer, my buyer decided to go, you said, okay, let's do it. And you do nothing else but use the expired offer, that is not a good thing, that's not the right thing to do. Do you understand that?
Yes.
You need to ask to submit a new offer,
Wow. Oh, yeah.
brand new.
You can't
I think-
do an extension of that
No,
offer date?
No, legally you cannot, that's why the offer expiration, the expiration date is given to you on the contract.
Yeah.
That's what you put in. And when you are a listing agent, you may see, I saw it quite often, those people, unbelievable agents who do not put any expiration date, they do not put the expiration date there, it's illegal. The legality is to put in the date, expiration of.
Well, it
But it
automatically
says, yeah,
says that over
3 days.
3 days. So
The
whichever.
seller shall be deemed revoked and deposit, if any, shall be returned to buyer unless by the date and time specified in paragraph 3C,
Okay.
the offer is signed.
My suggestion, when you write an offer, guys, that's my recommendation, always put a date. Do not put 3 days from everybody. That's so many times, people have different ideas of 3 days. The best way, when you have this option, 3 days, 5 days, 17 days, the best way to put dates. That's the best way to do it, that's clean, that's good, that's practicable, that's really good, okay? So you do not use the expired offer. And these paragraphs, just the ones that you know, you're rejected, the offer can.
So the best way to handle that is when you're gonna write an offer, ask the listing agent, how long does your buyer need, your seller need for an offer to review the
That's,
offer?
I will never do that.
Oh, you wouldn't?
I will never do that.
Oh, okay,
I'll tell you why.
go ahead.
This particular, I will never do it. What
Okay.
I always recommend to my clients to put 1 day. No matter what, put 1 day to respond. Do not give them more time. That's how I do it.
Because they're
And it
waiting for
worked.
other offers.
It worked. Either you accept it or not, right? What else can be? But don't give them this longer time to say to someone else, oh, I have 2 offers now. I have 3 offers, I have 1 offer. I never do that.
And if the seller's out of town and can't be reached,
The seller is out of town, can be reached. That's a situation that you need to decide how to handle.
Well, you don't know that if you're not talking to the agent. The listing agent.
You handle it any way you like it. You go to your client and say, this is the situation. This is the situation, so what do you think? My suggestion may be this. But generally speaking, I talk on a very high level. Because we know that every transaction has its own, oh gosh, so many different
yes,
things, right? So bad things to deal with. Generally speaking, 1 day, don't give more, don't give more. Don't ask the listing agent, don't do that. Because you are not acting in your best in the interest of your client. I talk to attorneys about that, different attorneys, and they say that my strategy really.
And you're saying when you represent the buyer.
Yeah.
And
Yeah.
it's good for the buyer
Yeah.
to only give 1 day.
1 day only, don't give more, either they accept it or not. One way or the other, right?
Sellers usually get ticked off over that. Trust
yeah,
me.
very.
Because they wanna wait for other offers.
Well, no, it's just like, well, wait a minute.
Well,
But what if
Question.
just take it or leave it.
And here's the, yeah, exactly. Go ahead.
Oh, Edgar.
Oh, thank you, Connie.
Desiree has a good question. Yes.
We received an offer last night, oh, no, yesterday at noon, we received an offer which expired at 8 PM last night. I couldn't get a hold of the seller, so what do I do?
Yes, that's a very good question. 8 o'clock at night is not a good time to ask the seller to respond. That's not a good time. You are absolutely right. Daryl, do you have an answer?
Yeah, what I've done in those kind of situations, and if there's enough time to get a hold of the buyer, I would try to put together an addendum or a amendment, excuse me, to the contract extending that period for a day or 24 hours.
Or you can just ask them to resubmit the offer if they're still interested.
Yeah.
So,
Yeah, sometimes you don't, like this one, it's noon to 8 PM. If you can't get it done in an
no,
hour.
that's very short. I
Well,
always
I've done
give
it
24
now.
like a day. That really works, guys. That really works. All
So
right.
what should Edgar do?
Edgar, so in your case, have you called the listing agent,
The buyer's agent.
the buyer's agent? Have you
Yes,
called?
I did, and I was planning to tell him to submit the offer again with today's date,
Yeah,
to make it cleaner, to avoid.
that's right.
maintenance.
You're right. You're absolutely right. Yeah, you're absolutely right. So I think that you have done everything possible in your situation, in that particular situation.
Yeah, that's
But
all you can do. It's just up to the buyer if they still
Yeah.
want it or not.
Yeah, absolutely. So, the offer expired, you cannot work with expired offer, that's given. Do not touch it anymore. So that's very important legal issue here. Then the next thing that we need to understand is, The next thing that we need to understand is that offer can be rejected. We already talked about rejection quite a bit. Withdrawn. When the offer is withdrawn, you need to do it properly, and that's why we see the card form WOO. Could you please show us this form, please?
It's a woo.
Ooh.
Yeah.
Been there,
Okay,
done
let's
that.
look at the form first and then.
Instead of a
We
W
cannot
O
do
to
over-
W O.
This should be done properly, guys. You cannot just say, "Whoa, we're no longer interested." We cannot do that. So this should be done with this form, right? Right.
Okay.
Okay, very good. Well, yes, Desiree
But
has.
this is if it's withdrawn during the period what, and has not expired yet.
Mhm.
It's
Right.
withdrawn
Yes.
before it expires.
Right, or
Yes,
desire
yeah.
to change their mind.
Yeah, okay, Desiree has a question. Let's hear Desiree.
Oh, just back to when you were saying to just give it one day, right? Okay, but what if the offers get submitted on Wednesday, but they're accepting offers till Friday at noon?
Well,
No,
they'll
they
send
wouldn't be
it
able
till
to-
Friday.
They're not reviewing it until Friday.
Yeah, so like, if you're giving it a 1 day, the buyer's giving the seller 1 day to make a decision on accepting their offer. And they submit an offer on Wednesday, but they're still accepting offers till Friday, then that surpasses the date. So how does that work?
Yeah, it may not work in multiple offer situation, guys. Again, you will go by what the listing agent says. Let's say you are the listing agent, you said all offers will be reviewed on a certain day.
As they come in.
As they come in or on a certain day. Normally I see on Friday.
Yeah, but.
Yeah.
Yeah,
So
but you
then
can
you would-
force,
Your offer would expire and you put the specific date in there, so.
So you
it may-
put the date that they require.
What, Darryl?
not to-
Okay,
or
that's
you
an
can
exception
force
number
their.
As an
one.
exception,
You
yes.
can say,
Okay.
If you are in multiple
Well,
offers,
hang
you
on.
follow what
Don't
the agent
confuse.
says,
That's
they will
right.
be reviewed. But you can
Yeah.
still submit the
That's.
offer.
Lauren,
Okay, but I will with 1 day.
No,
Okay.
next
Fine.
Yeah.
No, we're talking about not
Keep her on the base.
situations where, yeah, like generally speaking, it's a good idea to put 1 day. It's a good idea to put 1 day, no matter what, whether the seller likes it or not, either they accept it or not, that's what will happen and your buyer will know. Let me understand what the extra day will give to the seller. What if you put 3 days? 3 days, my goodness, they can find another offer, they can do all kinds of things. Actually, that's how I bought a property in Tahoe. That's what I brought. I gave them 1 day. There were no multiple offers, and the moment they signed it, it's just the pouring offers. That's what happened. I bought property in Tahoe.
Yeah.
So that's what happened, guys. So it's up to you. I'm telling you my experience, my thinking, what might work the best.
You know, where I have, I mean, let's talk about the multiple offer situation. As a listing agent, it's hard to explain away, you know, you'll see a listing saying, no preemptive offers, please, right? But you get a good one, they wanna take it, how do you then explain to all the other people out there? That, oh boy,
Oh,
it's
no,
my turn,
you-
you guys all understand where I'm going, right?
Yes, yes. I,
we had one in.
do you have any responses to this situation? Do you? Karen, how would you handle that?
I've been on the opposite side of that, where they took an offer before, my buyer, it said offers due on Friday and they accepted an offer on Wednesday. It's very frustrating because they don't communicate, they just, all of a sudden it changes status on MLS. It's really hard for me to call my buyer and say, you know what, they accepted an offer before we got a chance.
But, and we've been on the other side, we had a listing, and I told people that came through agents, and I said, no, we're gonna, it's gonna be or not first come, first served, we're gonna take offers on Friday.
Yeah, when we had it.
But somebody comes in and goes, what if, and he's a sharp Indian negotiator, don't mean to be racist, but they're very sharp when it comes to this kind of stuff. So anyway, he said, what if I said, I'll give you 1.5?
Yeah, it was $100,000 over and a 5.
And I said, look, I don't make that decision, the seller will make that decision, and they looked at it and took it. And I had to
That's
call
the right
everybody
answer.
and say,
I love this ones.
yeah, and I had to call everybody and say, I'm sorry, I gave you information, but the seller changed their mind
Changed their mind.
and took the best offer that came in.
So
And they said, okay.
my
have a decent
suggestion in
Do you have it
case,
listed on MLS?
Yeah,
That
yeah,
you were accepted?
Yeah,
so
it's hard on the list.
send,
It's like go back.
Yeah.
send your offer as soon as
Like
you
an
can.
idiot, man.
Send it.
So did you change the wording on
Yeah,
MLS?
as soon as you can.
Yeah,
Just-
don't wait for the date.
Yeah. That's my suggestion,
Yeah.
don't wait.
Well, now I'm starting to see on MLS where they have an offer date, but seller reserves the right
Right,
to
yeah, so what's
accept
the
the
point?
preemptive offer.
Yeah,
So it's
yeah.
really.
This is a couple of years, 3, 4 years ago.
Yeah, this is a good actually disclaimer, this is to protect the
Yes,
seller
check
and the,
this out.
so guys,
So
did you
everybody-
hear that? That's a
Yeah.
good disclaimer to do.
Yeah.
Okay, very good.
But it basically nullifies the whole point.
I agree with you, I don't even know why they do that, I don't see, if they want to wait, they can wait. And say, okay, keep sending us offers, but we will
Yeah.
choose the best, the highest, the best, I don't know, it's very, I don't understand that, I don't know
Can
this
can
one.
I ask another one on that same note, and I don't lose my train of thought here? Sure, I did.
I left the station.
Anybody like to?
Seller reserves the right.
Oh, yeah, okay, here's the other thing, you got a deal, it's pending, but you get these offers. You know, or one he just signed, but another offer came through, you gotta show them what the other
Yes.
offer was,
Yeah,
right?
yeah,
You still gotta
yeah.
submit it.
Even if you already accepted?
Even.
Yes,
What is
unless
it?
you have written notice from the seller that he's not looking any more offers. She had to go to court over one of these like this.
But if it's already accepted, how could, why would you look at other offers?
Backup.
Yeah.
Well, then, now you
Yeah.
have.
But backup's just one. What if the offer you accepted is $50,000 or $100,000 less than the one that
Oh,
came in?
usually it is, because.
Yeah.
And that would cover paying 2 commissions on both offers and still give the seller profit.
But I thought you can only get accept backup offers if you accepted a contingent offer.
Well, hang on, what are you saying? No, I mean, once
You
he's
can-
setting that contract, he signed a contract, he's signed, but offers come in, you still have to
You
submit it.
still have to submit
You
them.
still have to show them.
He can still accept one.
Yeah, you can negotiate to a backup position.
Well, I was gonna say, yeah, what do you mean accept one? To a backup?
No.
Yeah.
Okay, guys,
Whoa,
let's,
whoa, that's a big.
okay, we are not talking today about backup
That's not
and
what the
counter
lawyer
offers
told
in
us
details.
years ago.
This is all kind of introduction to how to handle offers. Generally, we will talk more about it. So let's keep going because I really wanted to show something else. Yes, please, let's keep going to the my handout, please. So withdrawn, rejected, ignored, countered. All right, let's talk about counter offer today, and then we'll talk about backup offers next time. So could you please open the RPA first?
The BCO.
Yeah, let's open the RPA first. So we go to page
16,
16.
number 34.
16, 30, paragraph
Probably
34, purchase agreement. So
Yeah,
counter offers. So that page explains, that's the only place where we have counter, we'll talk more about backup offers later. But today we'll just talk about counter offers and acceptance of the offer, okay? So let's see, what do we have? Seller counter offer, so we use certain forms, right? We use
Yes,
certain
ma'am.
forms and we do have seller counter offer, we have buyer counter offer, and we have multiple counter offers. We have them all, right? So we need to use them properly. Next, so this is the paragraph that talks about counter offers. And let's take a look at that publication, car publication, please. Car publication. Yeah, this one, please. So if you want to learn more about counter offers,
Yeah, he's going to the link, but she has to sign in first.
Oh, okay. Oh, boy.
Write all that stuff down, right?
so please show people the title of the
Oh,
article.
there you go. Okay.
Counter offer forms. See, guys, it tells you about everything you need to know about car offer forms. It will be also on our resource center. And we have quick guide that tells you exactly how. We'll take a look at it in a second. So, Raymond, do me a favor, read only the titles of each paragraph. Like, for example, the first one, please.
Yeah, question one, what are the substantive differences between the seller counteroffer and the buyer counteroffer?
Okay, keep going to the second one.
Question two, what are the substantive similarities between the SCO and the BCO?
Next.
How do you sequentially keep track of the counteroffers?
Hold on. So guys, as you can see, it covers quite a bit, huh? And if you read it, you will see something you never probably thought about, right? So we need to study that, we need to understand that. Now the sequence, can you read that about the sequence? Can you read, because we did talk about that before. Could you please read the text?
Which one?
How do you sequence keep
Oh,
track?
okay. At the top of the form, the document is titled seller counteroffer number blank or buyer counteroffer number blank in the zip form platform pre-numbered versions. Many transactions involve more than one counteroffer being generated between seller and buyer. By using this form, the principals have an easy way to sequentially keep track of the counteroffers by writing the appropriate numeral in the blank line to the right of the title of the form.
But you gotta read the next one.
Okay, let's read the next one. What does it say?
If a seller counteroffer is number one, should the next buyer counteroffer be number one or number two? Technically, there is no correct answer. Love it. Either numbering system is acceptable if understood between the parties. However, as a matter of practice, most agents seem to be gravitating toward numbering where the first name of a form is used in its label as number one, and the second time it's labeled number two. So the seller first counter would be seller counter number one, followed by buyer counter offer number one. So you have two number ones, but one seller, one's buyer.
That's what we
If
decided.
the seller countered back, it would be seller counter number two, and if the buyer countered back, it would be buyer counter number two.
That's
I
what
love
we
it.
decided. I want to remind you guys, we did talk about that, and
Yeah.
we do not remember. So we do not use letters, right? We use only the count, we count the form, our form, we don't count their form. Okay, so if you have one, the second from you, two, the third one, three, they will do whatever they want. 1, 2, 3, 4, but at least it will be very separated. That seller has 3, the buyer has 2. It will be very easy to follow. Okay?
Better be very focused on the name.
Because it only matters which one it ends up getting signed, right?
Yes, eventually. That is the contract acceptance date.
What do you mean it only matters which one is signed? They're all gonna be signed,
They're all
either
gonna
as
be
I
signed.
counter.
Well, in this case, it's not a multiple counter. This is a single offer.
Yeah, it's not the multiple.
So, and they used to have a tool, I don't know, I'd have to look on here again. There used to be a tool you could use for the multiple counter offer.
Right.
And,
Yeah,
and
yes,
Carr
yes,
would help you keep track. You still have it? Okay. Cause I haven't used one for a while, but anyway, it was a good tool. I built one myself in a spreadsheet.
Okay,
But-
that's good to know. That's good to know. If you guys do not use it, it's good to look into that. So, Raymond, keep going please with the next one.
How does the seller exclude the liquidated damages and arbitration provisions from the contract if the buyer has initialed them?
Okay, so this particular, I spoke with Dorothy about that, and like we did talk about that as well. We're not going to read line by line. You can do it yourself, but both parties needs to sign. Then it will be the contract. There is no one like, oh, my buyer does not want to sign.
Don't you counter that?
Yeah, you
You have
do,
to counter.
you do, but the bottom line is there is no agreement if only one signature. There is no agreement, okay?
Yeah,
So we
technically,
need
you
to-
could just not, one side could
Yeah,
not
we
initial.
need, it's
and then you-
mutually agreed upon, if it means meeting of the minds, right, guys? Meeting of the minds, okay, keep going.
Wait a minute, but if one signs and the other doesn't,
You don't have.
but you don't have a contract.
No, you do, but but that paragraph is not included. That paragraph to be included in the contract, both signatures have to go,
Yeah.
initials have to
To
be
be
there.
mutually agreed upon.
Okay, I thought you should document
But-
on that counter offer that seller does not agree,
Yeah.
so that's.
CAR asks you to do the
Both.
form and do a counter.
Yeah.
Because they like that better for
It's
clarity.
clear, yeah.
Yeah.
There's no
Okay,
question.
let's keep going, please.
Okay,
What's-
if the seller has used the SCO to exclude the arbitration or liquidated damages provisions, how can the buyer counter to include them?
Okay, so let's do this. All these questions we will talk again when we talk about liquidated damages.
Mhm.
But go back please to the title of this article. As you can see, it's a very good article. It answers a lot of questions that we have and nobody knows about this article. Not too many people, at least I know. So this is a good article. It will be all available. We'll have beautiful, beautiful place where we'll have everything in one place. So it will be really easy to use and send it to your client. Educate them through these publications. Can you show us the counter offer quick guide, please?
Sorry, the which one?
Quick guide. Can you click on quick guide?
Quick guide, there you go.
Yeah, thank you. So it read the in bold the titles, please. Number counter offer, right? I see that.
Yeah, do you want me to read the whole thing or just the title?
No, just
The highlights.
highlights.
Okay. Numbering counter offers, adjusting down payment and loan amounts to match price changes, liquidated damages and arbitration provisions, withdrawing a counter offer, creating a binding agreement.
So this is thank you. This is excellent, right? It tells you exactly what we need to do in different situations, so you don't need to guess. Everything is legal, everything is clean. Thank you very much. All right, let's go to the next. What do we have next?
I don't know, we have 12:05.
Oh, well.